My name is Phil Cavish, and I'm the senior partner of the law firm of Cavish, Minor, and Otis, celebrating over 25 years of service to the community. Now, if you're not familiar with our law firm, let me take a moment to tell you a little bit about us. We specialize only in estate planning and administration of estates after people pass away. We don't do criminal law, real estate law, contract law, divorce law, any other type of law than estate planning and handling estates, administering them once people have passed on. We're one of the largest estate planning law firms in all of California, and here in the South Bay area of California, where our main office is located, we are the largest estate planning law firm. We also have a state bar certified specialist on staff. That's important to you. Why? Because any attorney can call themselves a specialist in estate planning and administration. But to call yourself a state bar certified specialist means you had to take an extra bar examination and be reviewed by your professional peers in this field. Also, we have several attorneys with advanced degrees in tax law. Not just the normal JD degree that all lawyers have, but also an extra degree in tax law. And you will see, not only today, but when you do estate planning or administration, that what we do in the estate planning context does ripple into and affect a lot of other tax areas, not just estate tax, income tax as well. And then finally, our main office is located in Torrance, California, near the intersection of the Harbor and 405 freeways. But we also have offices throughout the Los Angeles and Orange County areas of Southern California. This may not be as important to you today, but in the future it may become very important for your spouse, for whomever else may be your trustee, your children or so on, and for your beneficiaries who will benefit from your plan someday. This makes us readily and easily accessible to them when the time comes. Now, let me share with you a little bit about how this trustee manual that we call To My Trustees, this trustee manual came about. One of the things that I have not told you as yet is that in our over 25 years as a law firm, we have actually handled over 2,000 living trusts of clients. This is an extraordinary number. If you were to ask most attorneys, how many estate plans, living trusts have you handled after clients have passed away? Well, they're likely to say maybe a few hundred. Many of them will say far less than that. We've handled over 2,000. The good news is that this has given us a great deal of experience that we build into the front end of the estate plan, and of course also becomes important in the administration of the trust once someone passes away. Unfortunately, here's what we also found. It doesn't matter whether you have the world's greatest living trust plan if the successor trustee fails to drive this living trust vehicle properly. Now, when talking about a living trust, I love to use the analogy of a car. And it's a good one because the trust maker, or technically the term for the person making the trust is the trustor, will purchase the car, pack their assets into it, and then that initial trustor will drive the car as the first or initial trustee. Now, if husband and wife together are making a trust, typically together they'll be the initial what we call co-trustees of the trust. Now, someday a successor trustee will have to step in. This could be if you're married, if either of you becomes ill, disabled, passes away. If you're single, of course, if that happens to you. And at that point then, the surviving spouse, if you're married, or some other family member or friend will likely then have to step in, hop behind the wheel of that living trust vehicle and transport the assets to the people that you've intended to get them. And here's the thing. The good news is that when that next successor trustee, that next driver of the trust vehicle steps in, he or she can take over and run down the road immediately. They don't have to first stop and get a license, go into the DMV, go into the courthouse, into a probate, they get to avoid the delays and expenses of all of that, assuming you properly keep all of your assets in the living trust. This sounds like a big positive, but it can also be a negative. And here's what we have found. The problem is that most individuals who've been named as trustees have never done this before. They've never driven a living trust vehicle before. They lack the training to do the job right. And remember here, we're not just talking about some other family member. It might be your spouse if you're married. And if that successor trustee, whether spouse, family member, friend, whoever, they jump behind the wheel without ever getting driving lessons, well, you can kind of guess what might happen. They may crash that living trust car or vehicle. Now, you might be asking, what can really go wrong with a living trust? I thought it acts simply. It acts outside of the court. That is true. However, the trustee, just like a car driver, is obligated to follow the rules of the road and is held accountable to the judge and the beneficiaries, the people who will benefit from the trust or inherit it. That trustee is obligated to them. Obligated, and if they fail to carry out their legal duties properly, or if they violate the rights of the beneficiary, their obligation to the judge and the beneficiaries can be a heavy one. In fact, what a lot of people don't realize is that in some cases, if the successor trustee does things wrong, they don't do them in a timely manner, well, that trustee, that individual, can be held personally liable out of his or her own funds for the mistakes they may make, even if they're inadvertent, even if they're unintentional. Acting as a successor trustee, like driving a car, is a role to be taken very seriously. Now, this trustee manual is intended to act as a driver's manual, to assist you to make sure that you do drive that living trust vehicle properly. Remember, if that trustor is deceased or disabled and was married, this manual is important for the surviving spouse too, because that surviving spouse now becomes the first successor trustee. This manual explains what needs to be done in plain English that you can understand. We took great pains to take a lot of technical jargon, distill it down, translate it into plain English so that you can readily understand it and use it properly. This trustee manual contains practical step-by-step checklists and valuable guidelines so that you, as a successor trustee, can steer clear of the potholes and the pitfalls for the unwary. Now, the purpose of this video is really to provide you with a quick start, to allow you to immediately jump in behind the wheel of that living trust vehicle and handle the necessary trust affairs promptly and properly. And this manual and this video are intended to provide you a roadmap describing the lay of the land as you begin to drive through it. You need to continue to watch this trustee video and perhaps even take notes even before you begin reading the manual itself. In fact, you may want to watch this video a second time before reading through the manual. Now, let's first acquaint you with the general duties of the successor trustee. So again, if you're married, this may be the surviving spouse. If you're single, whomever else you may have named, family member, friend, so on. And remember, the successor trustee will come in if that original trustor, trust maker is ill, disabled, cannot act, or deceased. Now, the general duties of the successor trustee fall into three categories. First of all, you must handle assets. You must collect them. You must value them. You must manage them. For example, real estate that may need management, or stock and bond portfolio that may need management. And you may need from time to time to invest assets or make investment decisions, such as if you have excess cash funds. Second, you must pay the debts, expenses, and taxes, income and estate taxes. And Finally, you must make distributions to the beneficiaries named in the trust document in accordance with the terms that are laid out in the document itself. Now, you should also know the general rights of the beneficiaries. After all, you're going to be working with them and you want to make sure that you set up the proper relationship with them right away. The first thing is that you have an obligation and they have a right to be notified of major events, which include your taking over as the successor trustee. Typically, you will need to give them a legal document known as a trustee notice that informs them of the fact that you have now taken charge of that trustor's living trust. Usually, this will also include providing the beneficiaries with a copy of the trust document itself at that time. Now, if this is a married couple and the first spouse to die or become incapacitated or incompetent, many times the surviving spouse may not have to do these items, or these items may be waived. Now, another general right of the beneficiaries is information regarding trust assets. They need to know what's going on. They need an inventory of the assets themselves and accounting for transactions, sales and purchases, and moving accounts from one place to another, the income and the expenses paid. All of those accounting and inventory items the beneficiaries are entitled to unless they choose to waive this inventory and accounting. And quite frankly, this will often happen because the costs of the inventory and accounting will come out of the trust and effectively reduce their inheritance. So these items may be waived in writing by them. Also, another general right of the beneficiaries is timely distributions as provided for by the terms of the trust document. Now, the trust document may provide that someone's to get it as soon as possible after the trustor has died. Perhaps it will say that they're entitled to it over a period of years or as they reach certain ages. Perhaps distributions will be either mandatory or discretionary with the trustee. All of that will be laid out in the trust document. Now, as successor trustee, what actions do you need to take right away? Well, the first thing that you need to do, assuming that we have a Cavish Minor Notice client, is to locate this book that we call the Owner's Manual. This is a green book with gold lettering on the front, says Estate Planning Portfolio. Now, some clients have an older version of this where this is in burgundy and in gold, but it will again say Estate Planning Portfolio on it. It will be very important to find this manual because it will have copies of documents and a lot of other important instructions and information in it. Now, I'll forewarn you, many of our clients have taken that document and that portfolio or owner's manual and just left it in a book bag that we gave them when they left our office and put it in the corner of the closet. So you might want to look there. But seriously, if you're the trustor, the trust maker, you do want to have your successor trustee know where you keep that manual, and it's important to keep it in a place that is not locked so they easily have access to it. Now, if you cannot locate that owner's manual, or this is not a Cavish Minor Notice client, well then at least try to locate all the estate planning documents that you can. So included here would be, of course, the living trust. There often is a will that goes along with the trust. There are certain powers of attorney. There are certain health documents. There also may be something called a HIPAA authorization. And if it's a married couple, a document known as a property agreement. All of these are items that you should look for and make sure that you have the most recent ones in front of you. Sometimes a living trust may be changed by what are called amendments, so you want to look for them as well. Once you have that basic information, the documents, and some of the other information that you may find in the owner's manual, the next step that you take right away will depend on the status of the trustor. Now, what do I mean by status of that trustor? Well, the trustor may be disabled. This obviously is going to be different than if the trustor has passed away. If the trustor is disabled, in order for you to act as the next successor trustee, and this again includes surviving spouse signing a loan and acting as sole trustee now, the well spouse, you need to establish the incapacity of that other spouse or trustor before you can act. Sometimes incapacity is referred to as incompetency or disability and so on. And how you will do this will depend upon the terms of the trust document itself. Now, typically, our document requires that two doctors state in writing on their letterhead, I've examined trustor, and in my professional opinion, trustor is no longer capable of handling his or her own financial and health matters. And with two doctor letters like that and a copy of the trust, you'll be able to step in and take over. Now, sometimes instead of a two doctor letter requirement, perhaps there may be a committee of people named to determine whether that trustor is incapacitated or a single individual that's been named to do that. That's not typically the case, but it could be. You need to check the trust document. Now, the problem here is that while you're getting these two doctor letters, there may be more immediate needs that have to be attended to. In particular, there may be health decisions that need to be made for that trustor. And this is important to understand. As the successor trustee of the living trust, your primary function is handling financial matters. There also are documents that deal with healthcare decisions. The common one is called an Advanced Healthcare Directive. There are also ones known as a Durable Power of Attorney for Healthcare and a Living Will. You'll need to check those documents because it is possible that someone else may be named to make those health decisions for the trustor. For example, it's not unusual that perhaps one child is named as a trustee of the trust, but all the children are to act in making medical decisions. If that's the case, you'll need to get those other people together and make them aware that they may need to act or actually sign off or withdraw from acting so decisions can be made. You also should look for something called the HIPAA authorization document. You may need this. Why? Because you may need it to access the personal health information of the trustor, which typically is confidential and private by law. And you'll need this not only to make medical decisions, but you may need this HIPAA authorization to allow the doctors to release their letters stating that the person is incapacitated so you can act now as trustee of the living trust. Now, continuing on here, if the trustor is disabled and rushed to the hospital in an emergency, typically that person is not going to have on them their health care documents and other documents that may be significant at that time. If you have the trustor rush to the hospital and they do not have the health care documents, you do not have a copy of them, then you want to look for something that many of our clients have, something that we call a health document emergency card. Now, many of our clients that have either recently created their living trust plan or upgraded their plan over the years have this health document emergency card service. It's a terrific thing. And if you're a client and you don't have this card, you ought to contact us about getting this. Basically, here's how it works. We ask that the client, the trustor, keep this card in their wallet. Husband and wife would each get one and put it behind your health insurance card because you know the administrator at the hospital is going to be looking for that. And what this does is it notifies the hospital administrator right away to please call this 800 number, punch in that trustor's particular member and PIN access code, and the fax number of the hospital. And what this does is, this is a 24-hour fax on demand service that will immediately get over to the hospital a copy of the healthcare document and the HIPAA authorization so that immediate medical and health decisions can be made for that person. Now, once you've gone through those actions, then it's time to go into, again, this trustee manual. One of the first chapters you will see says immediate actions upon disability. There'll be a detailed checklist there of the next actions you need to take right away if the trustor is disabled. Well, what about if the trustor has passed away? Well, this may be a very difficult time for you and your family. And you may have great anxiety at this time. That's normal. The key things for you to understand is, fortunately, items don't have to be done as immediate in this situation. Believe it or not, the legal deadlines that come up here, typically the first one isn't until 9 months after the date of death. Now, that's not saying you should wait for 8 months before you get started, but the point is that there aren't as many immediate steps like where someone's disabled and you have to handle medical decisions, you have to take care of their finances for them immediately. You don't even usually need to be concerned about paying this deceased person's bills. The creditors will often give you a grace period so long as you contact them and let them know that this person has passed away. Here's a key point. You need to resist being pressured by anyone to do anything at this point, particularly if you are the surviving spouse. Unfortunately, in today's world, there are a lot of unscrupulous people out there. People who will want to convince you, you need to sign this, you need to pay this, you need to do this or that legal transaction. It is untrue. As I said, the first legal deadline that typically occurs is 9 months after the date of death. Don't be rushed into signing anything before you see your attorney. And by the way, if you have people that continue to pressure you, well, tell them to go see your attorney. That'll get rid of them pretty fast most of the time. Now also, if the trustor has passed away, it's important that you understand that the key thing now is for you to take care of yourself, particularly if you're the surviving spouse or a close friend or relative, as well as care for others who may be close to the deceased trustor, children, other members of the household, or other people that may be dependent upon that deceased trustor, maybe a parent, for example. You want to make sure that you take care of the family and emotional issues first. They're really the most important immediate steps when someone passes away. Once you've handled those issues and they're under control, then you can consult, again, in this trustee manual, the chapter, one of the very first ones, that is called Immediate Actions Upon Death. That will give you, step by step, the other actions you need to take care of right away. But what if the trustor is still acting as trustee? The trustor is not completely incapacitated, but is quickly slipping away. This is a situation that unfortunately happens more and more in today's world, because with modern medicine, very often people have a gradual decline, or what we call a twilight period, where gradually they're losing the ability to take care of things on their own. Or you might have a situation where the trustor, the trust maker, is not yet deceased, but they're very ill and death may be imminent. What do you do in these really unusual situations, but ones that have become more and more normal over time because of modern medicine? In these cases, the manual is of some help, but you do need to and should see an attorney immediately for more specific guidelines and preparation of legal documents that you may need in these situations as soon as possible. For example, the trustor may be gradually slipping away, becoming incapacitated. While they still have capacity, we may want to have that person resign or amend, change the trust, and place you in charge right now as the trustee, so you can take over things while things are not in an urgent state, when they're not in emotional upheaval, while you still even have that person involved to assist you. Or you may need to take immediate steps to qualify for certain government benefits that are needs-based, such as Medi-Cal, or nursing care benefit, in other states known as Medicaid. There are other forms of government benefits that this person may be able to qualify for that you'll want to take advantage of right away. And if the person is already getting these benefits, there may be last-minute planning that you want to do to preserve and protect the estate, because after that person dies, you want to protect against the government coming after those assets for reimbursement. Now, if the trustor is dying, you may also want to do last-minute estate planning. For example, updating their plan for new laws. Now, they may have the capacity to do this, they may not. If they don't, it is possible these types of changes can be made under their durable power of attorney. Their documents will need to be checked. Also, this is an important item for people that have larger estates. We may want to do some immediate estate tax planning, gifting to the beneficiaries right now, not waiting until death. Believe it or not, gifts can be made literally the day before someone passes away that could save tens, even hundreds of thousands of dollars in estate tax. So you'll want to attend to these last-minute items. Before you take any actions, however, you may want to consult the chapter in the trustee manual called A Few Important Do's and Don'ts. And I'm going to acquaint you with a few key ones right now. Do collect and lock up valuable assets and documents as soon as possible. This may mean changing the lock on doors, changing the lock on cabinets. It may be taking assets and inventorying them, putting them in a safe deposit box or in some other safe place. And you want to do this as soon as possible because you don't want those borrowers descending upon the house and grabbing items before you even have a chance to inventory them. They can make your life very difficult. If you are a co-trustee, now what this means again is more than one person have been named together to act as trustee. So for example, it might be surviving spouse and a child as co-trustee. You might be the oldest child and you have your brother or maybe your brother and your sister named all together to act as co-trustees. If you have co-trustees, you do need to establish communications with them right away so they're aware of everything going on and they'll be involved. And frankly, I'd have them view this video as well. You do want to set up a trust account as soon as possible. This is something that your attorney will typically help you with a few easy documents. You'll want to set up that account and deposit all of the income and pay all of the expenses out of that account and keep good records of those. It's not that difficult. It's not unlike what you would do if you properly take care of your own check register and ledger. Also, you do want to establish communications with the beneficiaries. This is really important. I'm not talking just about that trustee legal notice that you have to give them informing them that you're now the trustee. That's kind of a cold way to establish communication. I'm talking about a personal visit, maybe a personal phone call, or a letter. It's very important to develop a personal relationship here with the beneficiaries because, as you'll see, you'll be working with them throughout the process and you want it to go smoothly. And please do be compassionate and patient with them if they're excitable. They're probably going through a lot of emotional strain, a lot of anxiety as to what needs to be done or is not being done. You must be conscious of the fact that you need to be calm. That is your role as successor trustee. That may sound difficult because you may be one of the family members or you may also be a beneficiary under this trust, but it is your responsibility to keep them all calm and on focus with what needs to be done here. Now also, let me go over the don'ts. The don'ts are perhaps even more important than the do's. Don't use assets of the living trust for your own personal reasons. You cannot pay your personal expenses from there. You cannot take distributions, even if you are one of the beneficiaries, take distributions for yourself before you make proportionate distributions to the others. You'll get yourself in trouble if you do. Don't act alone if there are other co-trustees. Those other co-trustees will need to co-sign with you or consent to many of the actions you will do, including co-signing at least initially on opening the bank account, although later their signature can be delegated to you so that you alone can sign on the account. Don't commingle trust money in your own personal accounts. Now, it may be possible that until the trust account is open, you had some income, you deposited the checks in your own account, but be very careful to immediately, as soon as that trust account is open to transfer those assets in there. Keep good track of them and any interest or earnings on them. Also, there may be immediate expenses that you have to pay. For example, a funeral expense, and you haven't opened the trust account yet. It's okay on some of these immediate expenses, if you need to pay them out of your personal pocket, to do so. Once you set up the trust account, you can immediately then reimburse yourself for reasonable types of expenses related to the trustor's passing. Don't fail to respond promptly to reasonable questions and requests of the beneficiary, or fail to do so courteously. This item is where most successor trustees get themselves in hot water, because many times you as successor trustee may not like these other people. Maybe you don't like dealing with these other people. Maybe you just want to avoid them. The problem is that if you do not respond to their requests and reasonable questions in a prompt manner and in a courteous manner, here's what's going to happen. They are going to become suspicious of you. They are going to lose trust in you, and very often they're going to cause fights with you. And I would bet that you definitely don't want to stir up family conflict, either over this or all those old family conflicts of the past. So it's very important to be responsive and communicative in a courteous manner with the beneficiaries. Now, you're about to start reading the manual. Let's take a quick look at how it's laid out. What you may want to do is open the manual with me here and go to the first tab, the table of contents, and follow along with me here as I go through the next portion of this presentation. The Successor Trustee Manual has checklists of immediate actions you must take in front. Those are the first few chapters in there. We've already referred to the checklist if someone is disabled, incapacitated. We talked about the checklist if someone dies. There are actually two of them. If that person who dies is the first spouse of a married couple, or is the surviving spouse or an individual. Those checklists are in front for a reason, because those are the things that outline the immediate steps that you have to take. Then the remaining chapters behind the checklist have more detailed backup for many of the steps that appear on the checklist, such as how do you review the trust document and other legal documents? What are your trustee duties and what powers do you have as the trustee? How do you invest trust assets? How do you handle income taxes and estate taxes? How do you do the accounting? And how do you make distributions to the beneficiaries? All of these details and more are laid out in the later chapters behind the checklist. And very often the checklist itself will refer you to that later chapter at that particular point. In fact, as you work through each item on the checklist, you want to consult the corresponding more detailed chapter that relates to that particular action. Now, at the very back of the manual, we also include some other very important tools that you'll want to use to get and keep organized as the successor trustee. The first one is a directory for you to place on it important addresses and phone numbers. Well, who would we be referring to here? Well, for example, the employer and their phone numbers, the financial advisor, the accountant or tax preparer, perhaps doctor, family members, the beneficiaries, successor trustees, and so on. This list will become not only important for you to refer to later, but will be important that at some point, if you no longer can act or no longer wish to act, the next successor trustee can step in and have this important information at their fingertips. Also, there is something we call a location list for you to complete, where you keep important legal documents, such as all of the trust documents, such as income tax returns, passports, birth and death certificates, and so on. Now, you may be wondering, if you've been named as the successor trustee to act, what am I getting myself into? Or, if you're the trustor, the person who made the trust, You might be wondering, who would ever want to be a successor trustee with all this stuff that has to be done? Well, no doubt the idea of acting initially as successor trustee with all its responsibilities and potential liabilities can be overwhelming. It can be a daunting task that you have in front of you. But there's a very important thing to keep in mind here, that you can hire qualified professional advisors to help you, an attorney, CPA or other tax preparer, financial advisor, real estate agent, and so on. You don't have to go this alone. You can get professional help to make the process a lot easier for you. And the good news is that you can pay these professionals reasonable fees from the trust assets, in addition to any compensation that you might be entitled to for acting as trustee. Now, you'll need to check the trust document itself to determine what amount of income, what amount of trustee fee you may be entitled to, and when it can be paid to you. Of these outside advisors, this is a word of caution to keep in mind. It's best to consult with the attorney first, before the CPA, before the financial advisor, or anyone else, as the attorney is in the best position to quarterback this team of advisors in a trust administration. The lawyer probably has more experience in doing this and knows the law. This is key, because other advisors may know a segment or a part of this administration process but don't have the full scope of it. And what we have found can happen if they step in first unknowingly, their actions could cause a lot of negative repercussions down the road. So see the attorney first and allow the attorney to then coordinate with the other advisors. Now, also, should you wish, our firm offers a free initial consultation with you as successor trustee. If you qualify, please give us a call if you'd like to see us. Now, most of all here, I want you to keep in mind that so long as you act honestly and with good common sense and hire qualified advisors to help you, you'll probably be fine. So here, I want you to take a deep breath and relax. Everything is going to be fine. Now, I do have a few disclaimers and reminders as a wrap-up here. One is that the trustee manual will likely undergo revisions or changes as the law and planning changes arise. So you may want to contact us at Kavish Minor Notice to see if a newer edition is available for you to consult before you act. Also, this DVD and the trustee manual do not constitute or substitute for appropriate legal advice. This is just general information that we've given you here. In order to have an attorney engaged to give you legal advice, you will need to sign a separate written engagement letter with them detailing out how that will work, and it's very important that you seek an attorney to do that properly. Another disclaimer and reminder is that this DVD and the trustee manual are copyrighted materials that may not be copied without the express written consent of Kavish Minor and Otis. If you do require extra copies, such as for a co-trustee or a future successor trustee, what we have found, for example, is that if you're the surviving spouse, you'll probably need a manual for yourself. Perhaps you would like to have a manual in the hands of your child or whomever else is going to act when you're no longer able to, so that they will have a head start on this and understand their duties, responsibilities, and steps they need to take. Or there's more than one trustee acting together. You're acting with one or two other co-trustees. You may each want your own trustee manual. All you need to do is simply contact us at Kavish Minor Notice and ask for our special discount on additional copies. Once a first copy has been purchased, any additional ones are available at a substantial discount. Now, in closing, all of us at Cavish, Minor and Otis hope that you find the trustee manual to be of great help to you in carrying out the important responsibility of honoring the last wishes of the trustor. It's an important job and a great responsibility. We want to make sure that you do it properly. Thank you for watching, and best of luck to you and your family. Bye-bye.